of what's happening. If I have received a call from another member of a family in a guardianship who has some concerns about what's going on with the guardian, typically I listen. I don't share, but I listen. And I will call the guardian into my office as quickly as I can to try to figure out what's happening. Because again, in a guardianship, we represent the guardian. We don't represent the ward. We are still officers of the court, so if there was something that was a immediate danger to the ward, I can't think of a situation in my office that we weren't able to convince the guardian to do the right thing and follow through on some issues. But it's a little bit different than in an estate. Typically, both Peter and I probably both have a very similar letter that goes out when we open an estate explaining to an executor that we're representing them in their capacity as an executor and not individually. And so I think probably both of us have represented executors individually for claims for their fees or other issues in an estate. And so I try to take some time in both of those circumstances and explain to the clients what their fiduciary duties are. In guardianships in particular, we actually use a little brochure from the Bar Association explaining what the duties of a guardian are, so people know immediately what their duties are and what a fiduciary relationship means.
So that gets to the next question. Does an attorney have a responsibility to collect or possess or manage those assets, the estate assets? My general feeling is they don't unless they feel that the executor or the personal representative is going to commit a crime or misappropriate the funds or mismanage the assets of the estate. With the guardianship?
With the guardianship, again, in a guardianship we have a regular duty to account. So we're able to check in on folks and see how things are going. It's our practice at our office not to simply take a checkbook register or an Excel spreadsheet of what the income and expenses are in an account because we are representing that individual before court. Again, we're still officers of the court. So when I am doing an annual accounting, whether it be for an estate or a guardianship, I want to actually look at the actual bank statements. Because someone could come in and say, oh sure, mom has $104,000, but they've spent it. And they've just simply created a sheet of paper saying that they have it. And they're in some other kind of financial distress. So I encourage you to not only get the information from a client of how those monies have been spent, but actually to look at the physical bank statements. You may not want to file those in court, but you want to look at them and make sure that everything does in fact match up. So if there is something improper going on, we can catch that.
We have a question from the webcast viewers, real quick. What ethical rule requires that we not hold original wills?
Say it again, please.
What ethical rule requires that we not hold original wills?
I don't know that I can refer to that rule. It was my understanding that